Bismillahirrahmanirrahim. Assalamu alaikum, dear students. Hope all of you will be doing well with the grace of Allah. And doing uh, your homework assignments on time and studying the courses offered in this semester to you. Is with me you are studying business law, and some of you are studying corporate law. This topic is basically included in both courses of law, either business law or contract law. So I will be giving this lecture to both the classes. In previous lecture we discussed what basically contract is, what is its importance, and how a contract is made between the parties. There are social agreements and there are legal agreements. Social agreements are not enforceable in court of law, while legal agreements are enforceable in court of law. In today's lecture we will discuss what are those essentials which differentiate between the two types of legal agreements, that is two types of agreements, that is legal and social agreements, contracts and social agreements, and how you guys will enter into contracts while doing your own businesses, or you are managers in some firms in doing different sort of contracts and legal agreements with the suppliers, hiring new employees, doing exports, making contracts with government agencies like gas, electricity, and so many. So the importance of today's lecture, or the learning and development objectives, are that you guys should be able to conceptually understand the characteristics and essential of a valid contract and legal agreement. As I have previously told you that there is a difference between a contract and an agreement. What is contract? Contract is basically a legal agreement, while all contracts are, as I have told you, agreements, but all agreements are not contracts. Technically there are social agreements which are not enforceable in court of law, though they are agreements, but they are social in nature. So in this lecture we will see the different characteristics which make a legal agreement, and that legal agreement in technical terms in law is also called a contract. Coming to the next slide, boys. What are the essentials? There are 11 essentials of a legal contract. All legal valid contracts should have those agreements. If any contract does not fulfill any of the essentials, then it will be irregular, or if it is lacking some major essential, then it will not be at all a contract. It will be a void, a contract which does not even exist in eyes of law. If you go to court, it will not hear your case, and it will say that it is no plaint, it is no case which can be registered against some party. So what are the basic essentials or characteristics which make a A valid contract or legal agreement, offer and acceptance, offer from one party and its acceptance by the other party are what we call proposal and acceptance. Legal obligations, as you accept a thing, there arise legal obligations, rights and duties on both the parties which they will perform regarding that contract. So first is offer and acceptance, legal obligations, lawful consideration, capacity of parties, free consent, and lawful object, writing and registration, certainty of terms, possibility of performance, expressly declared void. These are the essentials. We will discuss them one by one. If a contract or a legal agreement has all these characteristics, then it can be enforced in court of law, and it will create rights and duties between the parties, or it will create obligations, as Salmond and Pollock says, between the parties, which both the parties must perform. Otherwise, if any party goes to the court of law, the court will enforce it to the force of state, through police, through other forces. Now coming to the first essential of a valid contract or legal agreement, offer and acceptance. Basically, what is offer and acceptance, guys? An offer is starting point of a valid contract. It is the AB initio of a contract, the ABC, the first step. There must be an offer by one party and acceptance of that offer by the other party. As if there are two parties, we assume A and B. A offer his car for sale to be on 8 lakh of rupees. That is an offer. That is a proposal. Now B can accept this proposal, this offer, or he can reject. If he accepts that proposal, then there arises some legal obligations on both the parties. Both of them will perform their part of the contract. That is, A will give the ownership and possession of the car to B, while B will pay the full amount to A, as they have agreed in the contract. When both of them perform their obligations, then it means the contract is executed and finished. Now, if any one of the parties have not performed, then the other party can enforce him in a court of law by suing him through his advocate. I hope you understand. It is not very difficult but a bit technical, boys and girls. The second is legal obligations. Any legal agreement or contract creates legal obligations on both the parties. It's very clear from the words legal obligation. No contract can create illegal obligations on any party to the contract. It is not a contract in the eyes of law. The parties to an agreement must create legal obligations, legal rights and duties. In business agreements, it is presumed that the parties want to create legal obligations. If the parties does not create legal obligations, for example, somebody is involved in money laundering, i.e. making money in this country and then shifting his black money through some sources out of the country, investing in some other country, then it is illegal. Anybody involved in money laundering in Pakistan or even in other country is dealt very seriously by the law, and it is nowadays considered a crime against the state, financial terrorism, and states are very vigilant and very strict in applying its laws on money laundering. Unfortunately, in Pakistan, Many cases come to the court, but in one way or the other way, the people who are guilty, they were not punished to the logical ends. That is why we are seeing so many corruption cases in Pakistan, while in China, people who are caught in money laundering or in, let's say, in illegal agreements like bribes, things like that, they are hanged. The only law is if people who are guilty of bribes, financial crimes against even other party, and that the state considers a crime against the state, and the state comes a party in any financial crime and give a very serious and very severe punishment, and that is death to the people involved, and if they are found guilty by the court. Hope it's clear to you, boys. Consideration means lawful consideration is the third important essential of any legal, and you must see that what is the consideration for both the parties in the contract. Consideration means something in return, means price paid by one party for the promise of the other. For example, A wants to sell his car to B on 8 lakh rupees. In this contract, the consideration for A is what? 8 lakh rupees, while the consideration for B is the car, if he accepts the proposal of A. This is very clear, very crystal clear. The consideration should again be lawful. Unlawful consideration cannot be enforced in court of law. Okay, there are many examples of unlawful consideration. That you give me this license and I will pay you some bribe. This is example of unlawful consideration. Now, capacity of parties is the other important essential and characteristics of any valid contract or legal agreement, and you guys should be very clever in understanding it. A contract is only made by parties who are competent to do a contract. That means what? They have the age of majority. In Pakistan, what is the age of majority? More than 18 years. When you attain the age of 18, you can vote, you can do business, you can do business transactions, and they are of sound mind. They have not any mental problems. Both the parties. If anybody has a mental problem, psychological problem, due to which he cannot take a sound decisions regarding any business interest, so a contract with that person is considered in the court of law as void and not disqualified, but the law sometimes disqualifies some people because of their previous record. They have been, let's say, bankrupt, or they have involved in some bribes, and law says that they cannot be in they cannot do any financial transactions with anybody. Law declares them that they are disqualified from any financial activity, so their capacity is incapacitated by court of law. Free consent, it's very important, but it's very difficult to see, to actually operationalize this concept of free consent, because I don't think so that consents are 100% free in this world. There are one or other limitations which compel one or the other party to do a certain thing or not to do a certain. The consent of parties entering into contract is free if it is not obtained by some by, let's say, coercion, that is use of force. or threat, undue influence due to you are senior, you are father, you are senior manager, or you are landlord and the other person is tenant. That is undue, somebody influence you to do a certain thing. Fraud, actually the thing was the contract was done on fraudulent object. That is, let's say wants to sell his car to B, and the A says that the car belongs to him, while it is a car he that does not belongs to A. That means fraud. He do fraud and compel B, influenced B to enter into contract. Misrepresentation, again misrepresentation in papers. You buy a plot and they says to you that this plot is in Bahria town and it is its location, and they just show you that this is the location, this is the plot, but when actually you find out the plot exists in some other sector, or by mistake somebody mistakenly committed some omissions in the writings, and that has violated some of your right. That mistake should be corrected as per law. Hopefully you guys have understand these concepts, and they are very much important from business point of view, from social point of view. All the transactions we did in our daily life, they are based on some legal agreements or some contracts, and we must understand it while doing businesses, creating our own business as owner, like sole proprietorship, partnership, or private limited company, or let's say doing a job for someone else. Business goes on what? On agreements and contracts, and sometimes if you are unaware of the consequences of a contract or legal agreement, then you may be in trouble. So it's very important that you should thoroughly go to study them, take your books and some insightful videos from the YouTube, and come with some challenging questions in the live session. Thank you, students.